Welcome. To begin, I'd like to acknowledge the traditional owners of the land on which this meeting takes place and pay our respects to their elders past and present. My name is John Minns and I'm an academic here at this university, but more importantly this evening, I'm a member of the Refugee Action Committee here in Canberra, which is organising this event, along with our co-sponsors, who I'd like to thank as well for their efforts, the Australian Centre for Christianity and Culture, and acknowledge its Executive Director, the Right Reverend Professor Stephen Pickard. Friends, we are now in a situation where the shame of Australia's policy towards asylum seekers and refugees is laid bare once again for all the world to see. With the decision of the Papua New Guinea Supreme Court yesterday, what we in the refugee campaign have been saying for many years now has been supported. And that is that to imprison people seeking asylum indefinitely without benefit of charge or trial or sentencing is not only inhumane, immoral, it is illegal as well. And with the announcement a couple of hours ago by the Prime Minister of Papua New Guinea that the Manus Island Centre is to close, the whole policy framework erected by the government and the preceding governments that did so is a shambles, and the people on Manus Island and on Nauru who are its victims should be brought immediately to Australia. This hall has 1,335 seats. There are now well beyond that number of people in it and more people outside watching on the screens. And the size of this meeting, I think, says much about the depth of feeling on this issue and the great deal of support that this community has for asylum seekers and refugees, and, of course, the admiration and respect with which it holds our main speaker tonight, Professor Gillian Triggs. Emeritus Professor Gillian Triggs, as you know, is the President of the Australian Human Rights Commission. She was Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney and Director of the British Institute of International and Comparative Law. She's a former barrister. Of course, she conducted the National Inquiry into Children in Immigration Detention, which drew massive attention to the plight of refugees and asylum seekers suffering under Australia's detention regime. She was severely criticised for releasing the report, although her critics were not able to contradict the terrible facts that it exposed. And she showed, in our opinion, outstanding professional courage in her response to that criticism. To introduce Professor Triggs, please welcome Minister Yvette Berry. Minister Berry seems to be Minister for many things in the ACT government, but included amongst them is as Minister for Multicultural Affairs, in which role she has established the ACT as a refugee welcome zone. Please welcome Minister Berry.
Thanks very much, John, and oh, I'm a bit taller. There we go. I'd like to begin by acknowledging the traditional custodians of the land as well, the Ngunnawal people, and I pay my respects to their elders past and present, and I acknowledge the significant contribution that they make to the life of this city and this region. I'd like to especially acknowledge Professor Gillian Triggs, John Minns, the Chair for the Refugee Action Committee, and thank you very much, John, for inviting me along tonight. Bishop Stephen Pickard from the Australian Centre for Christianity and Culture. Thanks to the Refugee Action Committee for the invitation and for their ongoing work and advocacy. I was just talking to John on my way in and congratulating on the great work with the core flutes across the ACT that has been really shining a light on this conversation that we're having here tonight and hearing Gillian Triggs share her story and her knowledge with us. And it is my pleasure to introduce Professor Gillian Triggs tonight. Last night I was at a similar forum with ACT Human Rights Commissioner Helen Watchers. Both of these women have great minds who continue to lead the community discussions on the fundamental issues of human rights, and both are very important women leaders. These independent voices have been so independent and important in recent years in Australia as it has struggled with immigration policies, especially as we've seen the gap widen between where we are on this issue of how Australia responds to some of the world's most vulnerable people and where we should be. For some years now, we have seen a national debate without enough balance from our political leaders. But we've been able to draw on the contributions of people like Professor Triggs, independent office holders who answer to the community and to law. It's worth acknowledging our system of governments for protecting these important voices. They are vital to the cause of fundamental change in the way Australia responds to refugees and asylum seekers. But we're never going to achieve this change just in lecture theatres with legal and moral arguments, or by preaching to people because their views are different. We need to keep working within our communities. I'm a firm believer in trying to understand the different views which are different from mine and work with those people to change their minds and not to lecture them when they disagree with me. So I've spent time doing just that, talking and listening to people throughout our community about these issues. When you do this, you see how powerful the message of fear can be. When enough politicians and media figures tell people that they should be afraid, then they will be. Real life experience, of course, is very different. I get reminded time and time again of what a proud and welcoming home to different people and cultures Canberra really is. As a minister, I see every day the great contributions that migrants and refugees make in Canberra to our diversity, to our colour and to our strength. As a community, we value these things and we have the ability to share these things with more people, especially those seeking safety from conflict around the world today. And that's why, as Professor Minns mentioned, I was very proud to declare the ACT a refugee welcome zone last year. We were the first, and I hope that we're not the last, to be a refugee welcome zone. Our government in the ACT has been consistent on these issues, offering to settle Iraqi and Syrian refugees coming to Australia under the additional intake, offering refuge to children held on Nauru, and I'm currently finalising a request to the federal government, together with a number of local organisations, to have the ACT recognised as a safe haven enterprise visa zone. Thank you. And this will provide pathways for asylum seekers to become permanent residents. On that note, I've been very fortunate in the last week to meet some recently arrived Iraqi refugee families who will be calling Canberra their home. It was great to be able to welcome people who've been through such an ordeal to the safety of our city. Convincing other leaders of the importance of Australia offering this safety remains a challenge. It will take time and it will take determination from all of us. Despite our small size, the ACT does its best to set an example for others to follow. This includes stepping up on key legal and human rights issues. So it goes without saying, we put great importance on the work of people like Professor Triggs and her team. I saw in the Saturday paper, like most of you I guess as well, that she has put some very frank views on record in recent days. And I'm sure that tonight she will be as equally frank and informative. And so it is my pleasure tonight to introduce Professor Gillian Triggs.
Thank you very much indeed. Thank you. Thank you. Well, good evening, everybody. I was, of course, absolutely delighted to receive the invitation to speak to the Refugee Action Committee tonight, and I expected a few people in a cold local hall. I was absolutely not expecting this. It is a real testament, I think, to the ACT, to the work of Dr. Minns and Minister Berry, and each of you, that there is such a huge community response to this question. And I just wish that our political leaders could see the depth of a community feeling that I feel is here with us tonight. And in this glorious reception music hall, can I acknowledge the custodians of the land, the Ngunnawal people, and respect their elders, including those who might be here tonight. Well, as I say, I was pleased to receive the invitation to talk about the human rights of refugees, a very broad subject and one that I've been speaking about quite a bit. But of course, the timing has been absolutely impeccable. I did have a bit of a formal speech tonight, but I'm afraid I've rather eliminated it, and I think I'd rather speak to you directly about these quite extraordinary events that have been occurring in the last few 24 hours. Firstly, as has been pointed out, the Papua New Guinea Supreme Court has ruled unanimously, including a judge you all know from the ACT, that the detention of asylum seekers and refugees sent to Manus by Australia breaches the right under its constitution to the protection of personal liberty. This, I think we knew yesterday, would be a game changer, and I think it's become clearly a game changer because, as you will know today, the Prime Minister of Papua New Guinea has made the announcement that he will close the Manus Refugee Centre. He has decided that those who've been adjudged to be refugees, the more than 50% who've thus far been assessed as refugees, can stay in Papua New Guinea if they choose. Well, the reality is that of the 1,000 men who have been held on Manus Island, only 8 of those selected to be refugees have chosen to go into the Papua New Guinea community generally, and 3 of those have asked to be returned to the detention centre. So I think we can conclude that very few people will want to stay in Papua New Guinea for reasons that are really quite important ones to recognise. They have a different religious and cultural background. There is a strong sense that they are not welcome, and the Prime Minister himself has said that the detention centres run on Manus Island have damaged the reputation of his country. The next announcement has been, of course, that the Minister Dutton has determined that there will be no change whatsoever in Australian policy, and that these 850 men will and should remain exactly where they are. We now know that there is some possibility that they will be taken to Christmas Island. We also know that the Papua New Guinea Prime Minister has said some form of alternative settlement must be arranged, that Australia must, in effect, take its full responsibility for these asylum seekers. And finally, you'll be aware today that a 23-year-old Iranian refugee has set himself on fire on Nauru in front of the United Nations officials. I hope that that young man is in hospital and is receiving treatment and that he will recover. But it follows 17 suicides over the last 5 years from those in detention centres or who've been relatively recently released. In addition, of course, we've seen the very sad deaths, quite unnecessary deaths of some asylum seekers, one in particular, Hamid, of septicemia, and one, Reza Barati, who's been murdered. The story is a despairing one, and one that raises some very important questions for Australia, and much wider questions than only asylum seeker policy. And I'd like to spend some time today telling you a little bit about what I see as some of the greatest legal problems and humanitarian problems that we have yet to address. I think perhaps one point that comes immediately to mind for me with the Papua New Guinea's unanimous Supreme Court decision is how very different Papua New Guinea is from Australia. Because the decision of that court, and I've read it quickly, but it's a pretty clear decision. It was possible for the Supreme Court to reach a decision that there's been a breach of the right to protection of personal liberty, because that right is a part of the Papua New Guinea Constitution, a relatively modern constitution, I think, in 1975. What is extraordinary is that Australia has no such provision in our constitution, so that we are truly exceptionalist, and I'll come to this in a little more detail in a moment, but you'll all be aware that just a few weeks ago, the High Court of Australia, in a 6-1 decision, found that the offshore processing of asylum seekers and refugees was constitutional under the Australian Constitution. Now, I think nothing could explain more clearly the divergence in approach to basic human rights than that point of contrast. A relatively new, developing country like Papua New Guinea has a constitution that protects these fundamental freedoms, but Australia has not and chooses not to do so. But you'll all be aware that last year we celebrated the 800th anniversary of the Magna Carta, and you'll know that buried in the middle of that document about how many pigs and sheep you can have, and widows' dowries, and all of these rights, the breadth of cloth, the amount of wine in a glass to be sold by the publican. In the middle of all of this is that absolutely fundamental provision that Dr. Mins has quoted, and that is no man may be detained arbitrarily without charge or trial of his peers. Well, we've had thousands of people over the last 3 years detained, and many of them for many more years than 3 years. And this is something that, of course, we need urgently to address, and we have to address the options now for the offshore processing program. Will these people be transferred to Nauru? Will some go out to Papua New Guinea? Will others be taken to Christmas Island? We really don't know, and we haven't had any responses from the government today that are anything other than a determination to do nothing. But I think it's now absolutely imperative that each of those 850 men be returned to Australia, to mainland Australia, and that we have to think of the same policy of return of those who are held currently, about 500 people on Nauru. Just a month or so ago, I was at the United Nations in Geneva for what is known as the Universal Periodic Review. This is a process under the UN auspices of the Human Rights Council that every country is subject every 4 years to a review of its human rights record. And Australia had a review in 2011, and we attracted about 145 recommendations, most of which were then accepted by the Australian government, but 4 years later, November last year, it was clear that fewer than 10% had been complied with. Well, that's where we were in November. We then went through the process in which every one of 104 members of the United Nations stood up in the Great Hall in Geneva to raise their concerns about Australia's human rights behaviour. And the overwhelming issue that those countries raised was Australia's offshore processing, the detention for unprecedented periods of time of children and their families, the principle and the legal requirement of mandatory detention of unauthorised maritime arrivals, and other aspects of our refugee policies generally. Clearly, Australia's approach was viewed within the United Nations system as being out of step with international human rights standards. And these concerns were expressed not by states that might have wanted to have a go at us, nor only by those states whose human rights records themselves are poor, but by our traditional allies, by the United Kingdom, by Canada, by France and Germany, by China, and by many, many other states. And it was our turn in Australia to respond to those concerns and the now 290 recommendations made to Australia to improve our human rights. And the response by the Australian government just 4 weeks ago was that Australia's immigration and border protection policies have enabled Australia to commit to increasing intakes of refugees in response to the humanitarian crises in Syria and Iraq. The Australian government has no plans to cease its policies of mandatory immigration detention, turning back the boats or transferring people who arrive illegally. They also said that Australia respects and complies with its non-refoulement obligations, the critical provision of the Refugee Convention that you're all obviously very familiar with. But let me point out a special provision of the Migration Act in section 198, the heading of which is Australia's non-refoulement obligations irrelevant to removal of unlawful non-citizens. And that provision then goes on to provide that it's irrelevant whether Australia has non-refoulement obligations in respect of non-citizens, and that an officer's duty to remove as soon as practicable any unlawful non-citizen arises irrespective of whether there's been an assessment according to law of Australia's non-refoulement obligations. Now, my point is that we have a senior representative of the diplomatic service in Australia making a clear statement that Australia complies with our non-refoulement obligations, knowing that these provisions are in our Migration Act. In addition, Australia chose to accept some of the recommendations on a very particular ground, that the matters subject to concern in those recommendations are matters where Australia is already compliant with its international obligations. In other words, the response was, we don't have anything to be concerned about because we are already compliant. So the strategy has been to declare over and over again that Australia is complying with its international treaty obligations, when all the evidence in front of our eyes is that clearly we are not. About 50% of the recommendations were in that sense accepted on the basis that no change whatever was required, and the remaining 50% were in UN language noted, which means that they will not be considered at the present time. So the question that I'd like to explore briefly tonight is, why is it that Australia appears to have such an exceptional approach to refugee policy? And why is it that we're prepared to fly in the face of absolutely clear statements, whether it's within the United Nations system or the views of the Supreme Court of Papua New Guinea? We've also, of course, had the views of the United Nations Human Rights Committee in their monitoring processes, and we've seen the rapporteur for the Convention Against Torture make the extraordinary statement that Australia's offshore processing, in particular in Nauru with families and children, constitutes cruel treatment and punishment within that torture convention. How is it that we have moved to this position from those days that many of you in this audience will well remember of Dr. Clive Evatt going to the Dumbarton Oaks discussions to create the Charter for the United Nations, where he fought, by the way, against a veto vote, but fought in particular for the linkage of human rights with peace and security in the world. And he was then invited back by Eleanor Roosevelt to negotiate the terms of the Universal Declaration of Human Rights, which includes the provision that every person has the right to seek asylum and to claim refugee status. How is it that we've moved from that tradition of the 40s and the 50s all the way through the dominant role that Australia played in crafting the human rights treaties to which we're party? Of course, the Refugee Convention, but also the Genocide Convention, the Convention on the Rights of the Child, the International Covenant on Civil and Political Rights, the International Covenant on Economic Social Rights, and all of those anti-discrimination treaties in relation to sex, race, of course, and disability. How is it that about 15 years ago, one can almost date it from 2001, when we had the misstatement about children overboard, found out later by a review to have been inaccurate, maybe even based on bad faith, but by then the political moment had passed. A few months later, the Tampa boat is brought in against government instructions to territorial waters, and a few weeks after that, we have 9/11. And it's in that context, I think, that we've seen a breakdown in the rule of law, a breakdown in Australia's commitment to the international human rights treaties to which we've become a party. And as the Minister has said, the conflation of human rights interests with the fear of terrorism and of leaky boats arriving in large numbers. The climate of fear has been developed for political purposes over the last 15 years in a way which has led to a serious decline in the rule of law. But I return then to my question: how is it that a country that was such a leader in the development of international human rights law after the Second World War, how is it that we have retreated to policies not only in relation to asylum seeker issues, I might add, but to the rise of executive discretion without judicial oversight, anti-terrorism laws, laws that restrict freedom of speech, including those who, of course, go to the detention centres? How is it that we've come to this position? And the answer seems to lie in the highly exceptionalist approach that Australia has chosen to take, perhaps because we're an isolated country, perhaps because of leadership issues, but we have sleepwalked into a position in which we are now seriously out of step with the international community. We have very few constitutional protections for human rights, as you'll all be aware with this audience. We have a right to freedom of religion, we have a right to vote, and we have a right to be compensated if our property is taken from us. But beyond that, all of the common law freedoms that we have grown up with from the times of the Magna Carta and earlier have not been reflected in the Australian Constitution. Indeed, it's been for the High Court of Australia to imply a right of discussion and political communication as part of our representative system. But otherwise, we do not have a right to freedom of speech other than through the common law principles. We are the only common law country in the world that does not have a Charter of Rights. Now, that perhaps wouldn't matter so much if we had some provisions in our constitution, but we don't. But perhaps what's been even more disturbing is that the treaties that I've briefly described to you that were negotiated in the post-war years right up until the creation of the International Criminal Court in 1990, these treaties, for the most part, have never been given domestic implementation in Australian law. Now, this is a constitutional point, perhaps not an easy one for all Australians to understand. But it's one thing for our diplomats to go to New York to negotiate a treaty, but it's quite another to have that treaty applied directly in Australian law. And the phenomenon has been that the major human rights treaties, particularly the International Covenant on Civil and Political Rights, Convention on the Rights of the Child, among others, have never been made part of local law, of Australian law, and therefore we have the analogy of ships passing in the night. We have international legal obligations, but they can readily be ignored domestically because we've not given them domestic effect by legislation through Parliament. Parliament has failed to pass that legislation. So although I might go to see a minister, or we might put an argument before a federal or high court on asylum seeker issues, for example, but the answer I will typically get is, well, that's all very interesting, Gillian. It's within your mandate as the President of the Human Rights Commission. It's within our statute to talk about these treaties, and that is my definition under the Treaty of Human Rights. But they don't apply in Australia. So that we come to the Migration Act, and we find that not only are the terms of the Refugee Convention currently not in that Migration Act, but when they were implemented, they've now been stripped away. So that the question of who a refugee is no longer a question under Australian law of the refugee definition in the Refugee Convention, but it depends on the minister's definition and the language in the Migration Act inserted about a year ago. So that we've seen a retrograde step in Australia where principles that have been in existence for decades and assumed to be core and fundamental principles are actually not available. Now, that is why, and explains why, the High Court of Australia, in looking at the challenge to offshore processing in the M68 case, not very interestingly named, but the M68 case decided a few weeks ago, made the decision it did. Because there is a principle of law for our courts that if Parliament speaks with clear language, if its statutes are unambiguous, then there is no right of the court to reach out to the common law principles that we all assume exist in Australian law. They do exist in Australian law, but the courts cannot reach out to them because the language of the statute is crystal clear. So that in innumerable cases when our pro bono lawyers typically take the cases through the federal courts or up into the High Court, we find that the High Court is faced with the same problem, that the Migration Act in relation to asylum seekers is clear, and that any common law argument against the arbitrary detention of a person without charge or trial cannot be imported by the court and cannot affect the determination. So that we had judges in a 6-1 decision in that case finding that of course there's an aliens power, of course there's an external affairs power, and of course Parliament can pass legislation to enact the offshore processing system. Now, there is a ray of light in regard to this law, and that is that some year or more ago, the High Court of Australia, in a decision that received very little notice, it's called the S4 decision, was a very interesting one in which the High Court of Australia said you can either deport an asylum seeker or you can lift the bar and allow that person to make an application for a visa, and a decision must be made one way or the other. But the government cannot hold asylum seekers in detention indefinitely. Now, that is a principle, and it's one that we have yet to see play out in the courts, because we have to remember that although today and yesterday we've been so concerned about the 850 men on Manus Island, we still have about 1,500 people in closed detention in Australia, and of course over 500 families and children in Nauru. So this is the rather parlous and exceptional situation in which we're in. Few constitutional provisions, no Bill of Rights, very little implemented legislation, but absolute clarity in the statutes, and therefore the courts are bound to apply the language of the statute and cannot appeal to the common law principles that we would like to see. But what does all this mean? Well, firstly, I think I should acknowledge, and I do, the importance of the decision to release the children from detention, at least those in closed detention in Australia. They've been released into the community or into alternative community arrangements. There is some doubt about, in at least one instance, they have reclassified a formerly closed facility to declare it now to be an open facility. And we have to really investigate exactly how that is working. But there may be some good reasons, and in fairness, I should mention it. There may be good reasons for a wife and the children preferring to be within the vicinity of the husband held in another compound. The great risk, of course, is that many of the children who are now in the community are vulnerable to being sent to Nauru. And in that context, of course, it's been quite remarkable to see how the medical profession, the paediatricians, the doctors, have now determined that they will, if they can, prevent the return of these children to Nauru. I think that's been an important movement because people who study medicine, who are carers in society, are not politically active. They don't usually take on issues of this kind, but in this case they have done, and I think that's been a very important change. I think there is clearly, I think, a need for legislative change. The principle of mandatory detention of asylum seekers must be repealed. The average length of detention currently stands at 1 year and 4 months. Almost half the people currently in detention in Australia have been detained for more than a year, and a quarter have been detained for more than 2 years. As a result, Australia still has a system of detention that does not adhere to our obligations under international human rights law. We have, of course, continuing concerns about Nauru. We have reported on the conditions of Nauru in the Forgotten Children report, but those findings of the 34% with mental illness compared to 2% of children in the general community are now reported to be even worse than they were when we first reported. Of course, we have emphasised the children, and if I could just give you a couple of stories. One, when I first went to Christmas Island, and I've been there 3 times, one of the nicest stories I could tell about Christmas Island was after a long day of talking to people. I sat at a rather grimy table in the canteen, and I took out my fluorescent pens and a few stickers and yellow bits of paper and started to write up some notes. And a little girl came up, and she'd not seen these fluorescent pens and had no paper. So I gave her a pen and some paper, and within 5, 10, 15 minutes, there were about 12 children gathered around this table, all using these coloured pens and pencils because they had nothing with which to write, and they had no schooling for a year. And I remember that they didn't speak at that stage very good English, and because there was so little to share around, I said, share, and the children were all copying the word share around the table as they started to use these facilities. Well, things have improved. The children aren't on Christmas Island, and most of those children are now in the community, but it was an important memory for me. Another was the cruelty of these policies. A young girl of about 12, as intelligent and bright-eyed as my children and yours, told me about how she'd been subject to a request to her father in Somalia that she join the Mogadishu chieftains for what was very likely to be some form of sexual slavery. And the father refused. He was taken away and put in a Hessian bag and run over and killed by the cars. Her other siblings were taken away, but a wealthier or an aunt with some money in Kenya smuggled her out. she took the journey to Australia and arrived on Christmas Island, where she was given clean clothes, was looked after and fed. And she described the story of losing her family and coming to Australia, all dry-eyed and quite composed. But then she said to me, "I've been here for a year and I've had no schooling." And that's when she burst into tears. And I thought how interesting that a young girl of 12 understood that she could put up with extraordinary hardships and loss of her family, but the one thing she knew she needed more than anything else if she was to have a future was access to education. Well, I think things have improved, but certainly in Nauru we remain deeply concerned about the educational future of these children. A brief word about the legacy caseload. One of the aspects of this story that are not being discussed is that we now have about 30,000 people in the Australian community who have been waiting for their asylum claims to be met. I think one of the most distressing a series of interviews I've had has been people who've been waiting 3, 4, 5 years and their claims have not been met, and they haven't had, if you like, their day in court. They haven't been able to explain that they are refugees, and they are hearing in the media from senior politicians that they're mere economic migrants. But by failing to assess their claim, we strip away the last piece of dignity that these people have. Because once they are declared to be refugees, and ironically Papua New Guinea and Nauru have been through the process with refugees, finding about something like 85% of them to be refugees. Once they have that status as a refugee, then in a sense they're vindicated, they have pride, they are here for good and legally protected reasons, and they have certain rights that flow from the Refugees Convention. But when you leave them in a twilight zone in Australia without assessing those claims, you have really taken away the last hope that they have. And many, of course, have suffered mental illness and distress as a consequence. We have that problem then of needing to respond to those that remain in our community. We also have the problem of the so-called fast-track review process for those who are seeking asylum. I understand, 1,600 people have received a letter to say that they can now put in an application for refugee status. Sadly, for most people, these forms are 8 or 10 pages long. They're all in English, and they require extraordinary levels of documentation. But legal advice for them and help in putting their claims has now been withdrawn for most of them. If they fail in the first attempt with an interview to convince the officer that they have a genuine claim to refugee status, their claim, of course, will be denied, but they can then seek an appeal no longer to the Refugee Review Tribunal, but to a newly established Immigration Assessment Authority, which can only review their case on the paper. They will not be interviewed, they cannot produce any new evidence. We are very concerned that this will mean that very, very few people are going to get through an assessment process, even when it actually gets into gear. And you might know that only 38 cases have been reviewed by that authority since the process was brought into action. Well, I think you'll all be aware of the problems of temporary protection visas and CHEVs. Very few people are being offered these CHEVs. Very few are being given temporary protection visas, or if they are, they know that 3 years from now they're going to have to re-establish their claim and demonstrate yet again that they have a valid claim to refugee status. So they remain, in a sense, in a twilight zone, admittedly safe in Australia, but with no permanent settlement and no pathway to a durable solution for their situation. Well, there are many other matters that I could discuss. The continued use of the turn back the boats policy, despite the concerns of our neighbouring nations, the family reunion restrictions, the codes of behaviour for non-compliance within detention centres, the changes to the character test and the cancellation of visas for those who might have gained them. They are immediately, on failing the character test, rearrested and taken back to detention centres. It's one of those curious, ironic facets that the group that we appear to feel most sympathy for are the 500 or 600 New Zealanders who've lost their visa rights because of failure on the character test, but perhaps we haven't been concerned about the situation of others. There are, of course, others also that remain in indefinite detention due to the adverse security assessments. So in conclusion, and I know there are many aspects of this issue that you may want to talk about and ask questions about in a minute, but my general concern is that Australia is exceptionalist in our approach to human rights. We have not responded to the United Nations concerns in an appropriate way. We have continued to allow the slow growth of executive administrative detention without proper access to judicial supervision, very little practical access to judicial review, and I think we see a national malaise in our democratic liberties, a disregard for the rule of law, and a failure of our parliamentary scrutiny processes. I think these are very extraordinary times for Australia, and won't it be interesting if it's a decision of the Supreme Court of Papua New Guinea that calls on us to reconsider our policies, and my hope is that as we move into an election, there will be opportunities for all major parties to revisit policies for which I think we should truly be ashamed. Thank you very much. Thank you very much. Thank you very much.
Thank you very much, Professor Triggs, for that incisive and compelling analysis. We now have a very limited time for a few questions from the floor. There are a couple of microphones on either side of the stage here. If anyone would like to ask a question, we have a very short time in which to be able to do it.
Professor Triggs, my name's Jane and I'm a former employee that worked on Nauru for 12 months and I'm a whistleblower. The first thing... I'm actually bringing regards from my best girlfriend from Nauru in Tamworth, Amanda, who says you're amazing and fierce. My question is, given all the things that's been happening, particularly over the last 2 years, the tragic events in Australia, in Nauru and in Manus, the number of reports that have been written, including the Human Rights Report and the Moss Report, and the number of whistleblowers that have spoken out of the conditions and the impact of detention on the people and the abuses that are occurring by expat and local staff, I wonder what you foresee needing to happen for Australia to change the policies and go back to honouring the commitments of the international treaties and conventions that we're signed on to.
Thank you for the question, and thank you to your friend in Nauru. That is the key question. What is it going to take to change this policy? I think one of the particularly worrying aspects is that we rely on Parliament to stand up for basic rights, and we expect a debate in Parliament by the opposition, whichever it is. But the great tragedy in relation to these laws has been that they have been ones which the opposition has allowed to go forward. There's been a complicity of opposition with the government to allow this expansion of executive power and mandatory detention rules. And that is, I think, a relatively unusual position. We find it similarly in relation to counter-terrorism laws, where you get neither party wanting to allow any daylight at all between them on these policies. And when you have that, then you lose the tripartite checks and balances of a modern democracy. We have executive, which always wants more power. I don't blame them for that. King John did it and was forced to sign the Magna Carta. It's been going on forever. That's not surprising. But what is surprising is that we have a parliament that is not standing up to these breaches of fundamental principles that underlie our democracy, and they, in turn, have agreed to legislation which excludes the judiciary, so that the underpinnings of our modern democracy are simply being cut away without us really understanding that's happening. Now, to your question, what is going to make a change? Well, the fact that we're different from any comparable legal system in the world doesn't seem to have changed anybody's mind. It demonstrates to me our increasing isolation when we have a Prime Minister on being reproached by the High Commissioner for Refugees or the rapporteur on the Convention Against Torture saying, we will not be lectured to by the United Nations. Now, perhaps it would have been easier to say, to ignore them, but to demean the international legal system and the principles upon which it stands, principles that Australia has been so deeply connected with, is an extraordinary phenomenon in contemporary Australian society. And to find that there are many in the media and in the community, sadly, who see that as an acceptable approach to these standards. So I still haven't answered your question. What's going to change? Sadly, almost a cataclysmic event. I had thought initially that the suicides might, but before I came tonight, I started to add them up from 2010 to tonight. It's a shocking number, but they haven't moved concerns. I think leadership is the big change vehicle. If we have leadership to say Australia is better than this, Australia, of course we need to stop drownings at sea, of course we have to have a better regional approach to managing the influx of those seeking our protection in our region, but to stop the conflation of those policies with arbitrary detention of families and children and young men seeking our protection and seeking a new life. So I see the solution really being dependent upon leadership. And I mustn't say any more because we're just about to move into caretaker mode, and that's, I think I've said enough on that subject. Thank you. Any other questions? Oh, yes, this lady.
Hi, Gillian. Thank you so much for coming to Canberra. Just leading on from what you said, I'm Christina Hobbs. I'm actually the Senate candidate for the ACT Greens, and I worked... I think this issue around exceptionalism is so important. I worked with the UN for 6 years across Syria, Turkey, Lebanon, Jordan, Kenya, Somalia. I've never seen anyone treat refugees like we do. That's why I'm running. And I guess I'm really interested in starting to talk about solutions. And I think this issue around the Bill of Rights is a really important one, because today we're talking about refugees, but in 10 years' time it could be another issue.
That's right.
And my question is, have we seen other countries, any of our peers, adopt a similar bill in recent times? Do we have any good models, and what would be the steps forward in terms of working towards some form of Bill of Rights?
Thank you very much, and it's wonderful that you've had experience of the UN and understands how it works. A Bill of Rights. That was on the political agenda. We saw, I think, Father Frank Brennan running a national consultation process. The proposal was put forward, he recommended a Bill of Rights, and it was rejected, and the then Labor Party decided not to progress the matter. So the opportunity was lost, and leadership could have jettisoned us forward. And I might make the remark, if I may, that the very different approach in the ACT and in Victoria to refugee asylum seeker issues is, I think, in part a reflection of the fact that each of you has a Charter of Rights. So there's a very different culture because you speak the language of human rights. Or you don't even have to use the word human rights. You can talk about civil rights or freedoms or liberties, but you get to the same answer. But of course, in other parts of Australia, we don't have it. Although I understand that Queensland is looking at this, which is quite a remarkable phenomenon in its own. I didn't say that. But the question is a terrific one. What's a relatively recent one, and how have they been working? Well, I've just a couple of weeks ago got back from New Zealand, where they asked me to come over because they're really interested in why we are deporting New Zealanders. So they asked me to come over and talk about it. It was not really front of mind for me, but nonetheless, they are deeply concerned about it. But what is important is that our cousins just across the Tasman have had a Bill of Rights for 25 years. And you don't often get the formal declaration by the court that a particular piece of legislation is contrary to one of the rights listed. But what it's done is to change the whole culture and language of the country. And I must say I was hugely impressed by New Zealand. Of course, their treatment of their own Maori people couldn't be in more stark contrast than the way we deal with it. They've got everything they do is informed by the Bill of Rights. I think that the New Zealand model is one that we could look at. The courts can't strike the legislation down, but they can issue a declaration. They've only done it once in 25 years, but the principles in the Charter have underpinned all the legislation that New Zealand introduces and gives effect to. I don't want to be unrealistic, but I really do believe that we have to revisit the question of a Bill of Rights, because, as you say, at the moment it's refugee asylum seeker policy. 5 years from now it can be treatment of those accused of terrorist offences, the loss of citizenship for those with dual nationality. I have dual nationality. I'm not entirely confident how long I'll keep my Australian passport, but I hope so. But perhaps I can finish with a story, if I may. And one thing I've learned in this job, because I do tend to get a bit serious about what I'm doing, is that it's actually humour has the biggest impact on people when we call attention to these absurd laws. And if I can mention Sean McAuliffe, I'm sure you all know his program, Mad as Hell, and he had a wonderful one on the baby Firuz case. I spoke out about the baby Firuz case, standing in the sun in Christmas Island, talking to a woman who said to me, I've given birth to my baby in a hospital in Brisbane. I've now been brought back with my baby to Christmas Island. But I'm told that my baby is deemed to have entered Australia by sea and is therefore an unauthorised maritime arrival. Well, I thought that this was, but can you imagine in that environment with a distraught mother trying to explain to her what a deeming provision is in law? It was a very, very hard thing for me to do. But Sean McAuliffe did it 100 times better than me, because what he showed the picture of baby McAuliffe and he said, how dare baby McAuliffe come to Australia hiding in his mother's womb for 9 months to jump the queue and claim Australian citizenship. Well, in a 30-second grab, he'd done what I could never do. So I do think in the end we have to ridicule these laws, to draw attention to how absurd they are when we're dealing with human beings who have exactly the same motives, aspirations, talents that we do. And again, I think the Minister has made the point, and it's a very important one. Of course, there's an economic argument that refugees and asylum seekers bring such richness to Australia. We are a migrant nation. We've grown up and developed and become the nation we are because of this. Can we not open our arms with generosity? So thank you, and I wish you luck. Thank you.
Yeah, Professor, mine's a bit broader than that. I was interested when you were talking about the Bill of Rights, and a few people touched on it. And when you were talking about that we don't have any domestic protection, so is that the case that the government because I can understand why the government policy and we've got bipartisanship now, because it's a popular policy domestically. But is it the case that if there was enough fear whipped up for any particular case of incarceration, that it could be done to anybody if it was legislated?
Well, thank you. That is a terrific question because, of course, my mandate is human rights generally. And at the Human Rights Commission, as president, I have to personally sign off on 23,000 inquiries and complaints a year. And we are now discovering many, many cases of executive administrative detention of those with cognitive disabilities who are unfit to plead and who remain in detention facilities, usually maximum security prisons, for a decade in one case in Western Australia, 4, 5, 6 years in other cases that I've recently made recommendations on. Now, the point can be that somebody has committed an offence and they are dangerous. They're dangerous to themselves and they're dangerous to the public. So the executive must have a power to detain them. But my point is that they must be detained only under the supervision of judges and of proper medical supervisors. And we are finding increasing numbers of cases where it is beyond that. Now, other examples are ones that will have a lot of popular support. Continued detention of those considered to be sex offenders, who might have been convicted of an offence. They've served their time, but will then be detained for longer. Sadly, these provisions of administrative detention do have the greatest impact on Australia's Indigenous peoples. And I think that it is truly disgraceful. I'm not saying that they should not be detained or detained in appropriate facilities, but we have to examine the conditions in which they're being held. They need medical care and support, and maybe they are too dangerous ever to release, but we need proper legal processes, and I fear that we've been lacking that. So your question's a terrific one. Thank you.
I'm sorry, I know there are many people who'd like to ask questions. We really only have time for possibly one more.
Hello, Professor Triggs. I'm about to be a horrendous name dropper. My girlfriend Laura Sweeney actually works for you.
Wonderful.
I just wanted to ask you about your opinion surrounding claims for refugee status based on LGBTIQ claims. Yep.
Mm-hmm. Thank you. And in fact, in my written speech, I did in fact avert to this, and I'm sure you're well aware of it, that there are some young men on Manus Island who are homosexual, and they have been subject to, I think, a dangerous environment, and they tend not to leave their cabin. They feel safer there. Now, there is a story to this. We had gained an undertaking by the minister, the then minister, that no people of a different sexual orientation will be sent to Manus Island, and I left that meeting with the minister quite confident that it wouldn't happen, but of course it has happened. But there's another dimension to the problem, and that is that those that are of a different sexual orientation, or LGBTI, however it is as a matter of fact for that person, if they're on Manus and they're now being asked to make a decision to go on into the main island for Papua New Guinea, they will be existing in a community where homosexual acts are criminal and where they're subject to all sorts of discrimination. Now, this is not a large number of people, but again, human rights are about individuals, and they cover everybody. And it is simply horrifying to imagine the circumstances of that young couple. So it is an issue. The question that I think you're also coming to, or behind your question, is how do you get refugee status on LGBTI grounds? And there are some cultures in which they are genuinely persecuted, and it is a ground for refugee status, and I would expect that it will be recognised categorically. But again, one of the great difficulties, and I really haven't had time to talk about this, but one of the great difficulties is that the departmental officials are asking for documentary evidence of absolutely everything. Now, the problem for somebody who is gay is that in the communities from which they've come, they're hardly out in those communities. And they don't have a document saying such and such a person is gay. I mean, it is impossible to demonstrate this, and they are asked simply totally inappropriate questions in order to determine whether they have a different sexual orientation or not. I think that's one of the more demeaning aspects of our refugee policy. But we'll hear more and more of these stories as we get access to them. And of course, one of the points that's being raised, I think, in the context of Nauru is the secrecy and the secrecy provisions that will give a 2-year prison sentence to anybody who speaks out about the conditions on Nauru or Manus or Christmas Island or any of the detention centres. The medical profession bravely is standing up against that now, and there have not been any prosecutions, but it remains to be seen what will happen. The key thing isn't actually whether prosecutions have been brought, but whether there's been a chilling effect on people speaking out. But as we know, when you do that to the Australian people, they will speak out louder than ever before. So it's a failure. Thank you. Thank you.
Professor Triggs, I think that standing applause expresses our feelings very much and our thanks for not only your presence and speech here tonight, but for what you've done on this issue over a long period of time, and perhaps as well in providing that leadership of which you spoke, of which so many of our politicians are incapable. Finally, friends, we who want a different approach to asylum seekers and refugees will have to argue for it. We'll have to convince people of it. We will have to campaign for it. And tonight we thank you in the campaign for your presence here, but we also ask you to do more. We ask you to be involved with us in this campaign, and there are many, many ways in which you can be. As you leave the hall tonight, there'll be stalls with places for you to put your name down and to sign up to the campaign. You can do something perhaps even like make a donation to the campaign. This beautiful music hall actually costs more than $2,000, nearly $3,000 to hire for the night. On arrival, you will have received a flyer, I hope, or you can get one on the way out, like this, which is a new national campaign to sign a pledge for a just refugee policy. Have a look at it. It's very simple. It's 5 points. It's a simple and a rational plan for what could be done rather than the terrible policies that we currently implement. Sign it outside or online, pass it on and spread the word. The implications of the current policies that Australia has towards refugees, as Professor Triggs has pointed out, go well beyond the refugees themselves. They profoundly influence our rights as well, and I think in a more subtle way as well, they profoundly influence the kind of community that we are. If we want to live in and to leave to those who follow us a place based on decent treatment of our fellow human beings, on fairness and justice, including to the outsider and to those most vulnerable, join us to make it so. Thank you and good night.